This is Michael Popok, Legal AF. I had the pleasure of interviewing J. Michael Luttig, conservative icon, former federal judge, and a defender of the Constitution, in all ways, a true patriot. And he is apoplectic about the abomination, in his words, of this recent United States Supreme Court ruling granting, effectively, Donald Trump immunity from prosecution. He explains that all of the, in his words, preposterous arguments raised by Donald Trump's lawyers, who any constitutional scholar or constitutional lawyer worth his salt rejected out of hand upon hearing them, upon seeing them in the briefing. All of them were accepted by this United States Supreme Court because they were backing into a result. They wanted to give Donald Trump absolute immunity, and they backed their way into it. And that's the reason that opinion is so lacking in intellectual honesty. Tune into our interview right here. Throw a couple of observations or comments in the opinion itself, and then you and I can talk about it. I knew we were in trouble. Well, there's many ways I knew we were in trouble when I started reading the opinion. One of them was how they so downplayed the criminal conduct that's listed in the indictment. It's just a matter of a conversation that Donald Trump had with some people in the Attorney General's office, or where he threatened to fire them, and already made the decision. First saying they were only a reviewing court and not a trial court, and that the record was incomplete. It should go back to Judge Chutkan, of course. But let us jump in and tell you which of these is absolute immunity. And that's the conversations he had with acting Attorney General Jeff Rosen, with Jeffrey Clark, the weaponization of the Department of Justice, and the use of it to not just to investigate whether there was election fraud, to promote fraudulent theories that there was election fraud in order to stop the peaceful transfer of power. The way that they so downplayed and watered down the indictment, that combined with an oral argument, everybody up there, all nine, acknowledged that this was the first time in 250 plus years that a former president had ever been prosecuted. In other words, there's no floodgates that are going to be open. You know, Donald Trump is the first criminal president, other than Nixon, that we've seen in a long, long time. Yet in the opinion, Roberts said one of the justifications for absolute immunity, or all these levels of immunity, is because if they didn't do it, there would be some enterprising prosecutor in a future administration who would use the same statute and would open the floodgates to prosecutions. That has never happened in 250 plus years. So as soon as I saw that, your reverse engineering theory makes absolute and perfect sense.
Michael, the Supreme Court majority adopted, embraced every single one of the preposterous arguments made by Donald Trump. Going back to argument, as you just did, remember, I came on your show very soon thereafter, and one of the first things I said is the argument was astonishing in every respect. But in this respect, in particular, namely, that the Supreme Court of the United States for 2.5 hours never talked about the only issue before it. In fact, I think I said it on your show that I could only remember two times. I remembered two times when the parties tried to bring the court back to the issues that were before the court. And in both instances, the respective justices said something to the effect, counsel, I'm not interested in the facts of this case. I'm asking this hypothetical. The hypotheticals themselves, Michael, were preposterous, not only for the reasons you suggest, but also for the reason that I laid out at the beginning here, which is the president is alleged to have committed the gravest crimes under the Constitution and against the United States of America possible. Any lawyer, frankly, any man on the street would understand that there is not a hypothetical that even needs to be asked. One, and also courts and lawyers, they only ask hypotheticals to explore the outer limits of the rule that they're contemplating, or the rule that's being argued for by one or the other of the parties. Which is to say, the obvious. If the allegation before the court is that the President of the United States has committed the gravest crimes against the country possible, there is no need for any hypothetical at all, unless you are thinking what the court was obviously thinking that day and what it did in this decision, which is hold that for even the gravest crimes against the United States, the President of the United States, and Donald Trump in particular, is immune from prosecution.
Exactly, Judge. The majority, rather than do what you did, which was to say, when you're talking about crimes against Article 2, the very thing that gives you your power, but that also requires you to peacefully transfer at the appropriate time, when your entire crime is against the powers of Article 2, to then say that everything you do under Article 2 is somehow absolutely immune, turns the whole thing on its head. I mean, there's no greater abuse of Article 2 by a president in history than what Donald Trump just did. I mean, let me throw something out at you that's hot off the presses. And as expected, I was going to ask you about Justice Thomas being heard from and deciding to spend and spill most of his ink in his concurrence, suggesting that the special counsel is just a regular person that has no business and no constitutional authority, delegated or otherwise, to be a prosecutor, that the whole indictment should be dismissed for that reason alone. Now, while the majority opinion did not address that at all, we predicted, as everybody else did, and we did it on Legal AF, that this was going to be something that that Judge Cannon in Miami, who's considering the issue because it's up on her with a motion to dismiss. Now we just found out as we're recording this that Trump has filed a paper asking Judge Cannon to adopt Justice Thomas's position that the special counsel is invalid. And it was not properly delegated authority, was not approved by Congress, and is just a regular guy. He's not a prosecutor at all. And so the indictment should disappear. What do you think about that?
Well, it's just another example, Michael, of the multiple ways in which this Supreme Court went out of its way and beyond the proper judicial role to ensure that Donald Trump would never be prosecuted by the United States of America for any crime, any of the crimes that he committed against the United States. Yes, it was only Justice Thomas who spoke about the special counsel, but every one of the other justices who joined this opinion were just as intent, if not more so than Justice Thomas, that Donald Trump would never be held accountable for his crimes against the United States of America while this court sits.
Welcome back. The full-length interview is on the MeidasTouch Network on this YouTube channel. Free subscribe and help us get to 3 million free subscribers. If you like what we're doing here, that was from Legal AF, a podcast at the intersection of law and politics. We do it every Wednesday and Saturday at 8 p.m. Eastern Time, right here on this YouTube channel where you can free subscribe. Yep, I said free. And then you can pick us up on all audio podcast platforms of your choice. So until my next hot take, until my next Legal AF and or interview of J. Michael Luttig, this is Michael Popok reporting. Heary, heary, Legal AF Law Breakdown is now in session. Go beyond the headlines and get a deep dive into the important legal concepts you need to know and we discuss every day on Legal AF. Exclusive content you won't find anywhere else, all for the price of a couple of cups of coffee. Join us at patreon.com/legalaf. That's patreon.com/legalaf.